Hi, Praggies. It's Rachel Cohen, and I'm here to talk about a troubling trend in administrative interactions with court systems broadly, but this time the Supreme Court specifically. The New York Times is reporting that the Trump administration has submitted blatant falsehoods in a filing related to Donald Trump's desire to deploy the National Guard to the city of Chicago. There are a number of factual allegations that are in a a request for a stay at the Supreme Court level. Donald Trump in Illinois v. Trump, the case that has stopped Donald Trump from fully federalizing the National Guard and sending them into the city of Chicago. There's currently an order that prevents him from doing that. That order is in front of the Supreme Court. The Trump administration has requested a stay. And in their request for that stay, there are tons of factual allegations that rely exclusively on declarations made by DHS agents or DHS employees. This is a common pattern in administrative filing or in the administration's filings related to ICE enforcement activities. And we see that, I'll say it, DHS officials are willing to just straight up lie. And I don't think that it's a stretch to say that when it's not only been proven now in the New York Times, which investigated a number of factual allegations that the request for a stay rests upon, including allegations that the Illinois and Chicago police were unwilling or too slow to show up to defend ICE, including that ICE was under threat from quote unquote rioters, which the New York Times and also anyone with a brain can tell you were peaceful protesters, that some bottles were thrown after federal agents escalated violently with protesters tear gassing the middle of streets. And all of this rests on allegations about Miramar Martinez, who is a Chicago resident who was, like many Chicago residents, participating in ICE kind of rapid response following ICE agents, laying on her horn, letting people know that ICE agents were coming. ICE agents shot her 5 separate times, and then she was charged as though she had been attacking the ICE agents in question, despite the fact that throughout her lawyer maintained that she had not been doing so, that she had been following them, despite the fact that back in September, ICE shot and killed Silverio Villegas Gonzalez, who was a Chicago father, accused him of driving his car into them, risking their lives, and then had that promptly disproven by independent media reviewing surveillance footage. Just like with Silverio Villegas Gonzalez, Miramar Martinez, who thankfully survived to tell her story, went to court and said none of that ever happened. Her lawyer said, we have plenty of surveillance footage that shows that none of that ever happened. And ultimately, in discovery, there were texts that came out from the ICE agent who shot her, bragging about shooting her, bragging about how good his aim was. And it also came out that DHS had that agent drive his car across the country, and the car's at issue here because it was a car chase. There's disputes about who rammed whose car. The car was driven out to an ICE facility, and then the evidence was destroyed. The car was fully detailed before anyone could ever examine it. And so the feds dropped those charges against Miramar Martinez. That hasn't stopped DHS from posting press releases, from posting on their website, from talking nonstop about the threats that they face, the same way it hasn't stopped them from lying about these anti-ICE bullets. That's something that you'll see cited in opinions about the threats to ICE agents over and over again, is the shooting in Dallas where someone shot multiple people who were being detained. And then DHS claimed that it had been an attack on ICE and published a picture of, that's a little difficult to believe, of anti-ICE written in what appears to be permanent marker on the bullet casings. And so all of that to say, the New York Times did this analysis of the application for a stay that's in front of the Supreme Court right now in Trump v. Illinois or Illinois v. Trump, and found that it's full of factual inaccuracies. It's full of lies about what's actually happening on the ground in the city of Chicago. What's particularly terrifying is that these stay applications are being used frequently by the Trump administration and by Trump compromised judges to utilize something called the shadow docket, which is where the Supreme Court will stay an order, not publish an opinion explaining why they stayed in order, which is particularly troubling because in our common law system, the reasoning as to why a decision is made is extremely important for go forward law. And then we'll leave it there. And in these shadow docket cases, all that you decide off of is the written briefing. There's no oral argument. There's no kind of questioning from the judges. And when we see the Trump administration, when we see DHS come out with allegations that seem a little bit unbelievable or unbelievably convenient for ICE, it's important to remember that they have a history of lying and they will continue to do so. And it's also worth holding in your head that this happens often, not just at the federal level under the Trump administration, but in general. When people are murdered by the state, whether that is a police officer, an ICE agent, a military service member abroad, you can't assume that everything that the government is telling you about the circumstances that led to their death is accurate. But I think under this particular administration, we can often assume that those circumstances are, in fact, inaccurate as told by the government. So stay tuned. We'll certainly be covering the stay when it comes down or does not come down, but despite being a pragmatic optimist, I am an optimist, but I am pragmatic, and I suspect that the Supreme Court will stay that. And we're going to keep you posted here on Legal AF on the Midas Touch Network. Like, subscribe, follow along here on YouTube, on Substack, and everywhere else. See you soon.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.